Good afternoon. This is Lisa Ramirez from U.S. Immigration Law Group. It is a pleasure to be here with you this afternoon. We're thrilled to see the number of organizations, community-based organizations, healthcare clinics, students, individuals, a wide range of individuals who are participating in this webinar. I will be honest, this is the first time that our firm is hosting a webinar, but we felt that it was really important to offer this information for educational purposes for everyone, for individuals that may be impacted by the public charge rule, and as well as community-based organizations that are tasked with enrolling or registering individuals for public benefits. One of the kind of primary catalysts that caused us to consider hosting this webinar is because we had several individuals come to our office who informed us that they were sent to the immigration office by a healthcare agency when they sought to enroll for benefits to inquire about the implications of the utilization of these public benefits on their immigration status. That was very concerning for us, and we've worked with several clinics, community-based organizations outside the state of California over the last couple of months, and I was really eager to be able to assist our local community and those clinics and organizations within California so that we can all be better educated and hopefully educate our community and know exactly how we can best assist them in the steps that we can take. So without further ado, I will go ahead and get started. I thought it would be helpful to find out first in terms of who's listening on this webinar and to find out what type of organization or interest the individual has on the other end. So I'm going to launch a quick poll here I am going to see if you're able to see and answer which type of organization do you belong to. Are you a clinic or healthcare organization, a CBO that registers individuals for public benefits, a law firm or legal service provider, or an individual that has a personal interest, or perhaps you're not captured in any one of those categories and you fall into an other category. All right, great. So it looks like we have about 40% representation from law firms and legal service providers, about 31% individuals and personal interests, 29% others, so there might be a good category out there that we did not capture, and then 6% clinic and healthcare organizations. Okay, great. So I'm going to go ahead and get started. Now, most of you probably by now have heard in terms of the new public charge rule going into effect. Many of you have probably participated in the public comment period that was available through last December. On August 14th, 2019, the Trump administration announced the changes to be made to the public charge rule. One thing that I want to be clear about is that a lot of people believe that this is a new law. It is not a new law. It is a new interpretation of an existing law. Now, although many of us were prepared, at least those legal service providers and organizations and law firms, we were scrambling to try to get as many applications of individuals that would be negatively impacted by this new rule filed before the October 15th deadline, which is the date it was to go into effect. However, most of you are probably aware that there were several federal courts which issued injunctions, and it suspended temporarily the implementation of this rule. What many people do not realize is that the State Department, which is tasked with adjudicating immigration applications abroad through our embassies and U.S. consulates, has implemented this rule and will continue utilizing this rule for all consular processes. So why is it important? What is the significance in this change? So essentially, prior to this new interpretation of public charge, the government focused primarily on the petitioner or the sponsor, whether the individual has sufficient income or assets to assure the U.S. government that the beneficiary or the applicant would not be deemed a public charge. This shift has now focused away from the petitioner and the sponsor, and it redirects it to the applicants, and these are the categories that the government is going to be looking at: the applicant's age, their health, their family status, assets and resources or financial status, and their education and skills. So just very briefly, as far as age is concerned, if the applicant is under the age of 18 and over the age of 61, they will be presumed not to be of working age. Now, many of us know just from life experience that there are plenty of people under the age of 18 and over the age of 61 that are working. But it is a negative factor if they do not fall within that working age. They will also be looking at an individual's health. Now, part of the domestic processing for a green card application, for example, does require a medical examination, and the government will be utilizing information obtained on that Form I-693 obtained by the applicant to determine whether they have any issues or concerns related to pre-existing health conditions. They will also be looking at whether the individual has the ability or capacity to be insured. And we'll be talking primarily today, I'm going to be focusing on the health-related aspects. They will also be taking into consideration whether the person has an existing job, whether they have the ability to get a job, whether they understand the English language, whether they can speak, write, and read in English, and if they have any other professional skills or certificates that might make it more likely for them to be able to be employed. It does make it very difficult. The primary group of people that will be impacted by this rule are the low-income, low-skilled, undereducated, elderly, or disabled applicants. They're really the ones that are going to be most impacted by this new interpretation. We had many U.S. citizens that were interested in filing for their parents, most of whom were elderly, and many of them had medical conditions that would otherwise be considered a public charge that we had to very quickly, and I'm sure most of you that are legal services providers were in the same boat, trying to get those filed before the October 15th deadline. If you know of anyone that may be low income, low skilled, they do not have much education, or they're elderly or disabled, because this injunction is in place, the rule has not gone forward, but it is really important that if they have any of these factors that will be deemed negative in the evaluation, that they attempt to apply for permanent residency as quickly as possible. Okay, so I want to be very clear because I know that there's a tremendous amount of concern and misunderstanding about who will be affected. So the only individuals that will be affected by this new rule are applicants applying for a green card, so for permanent residency, applicants applying for visas abroad. It doesn't matter if it's a non-immigrant or an immigrant visa, temporary visa, any type of visa when someone is seeking to be admitted to the United States, applicants applying for a change of status within the United States, and then potentially, and this is kind of a unique category, but lawful permanent residents, so those people that already have green cards but have criminal convictions and they're returning to the U.S. after traveling abroad, or lawful permanent residents who have been absent for more than 180 days. They too are being evaluated for admissibility purposes, and this public charge rule will, once it goes into effect, will may impact their eligibility. Now, who will not be affected? U.S. citizens. If there's any U.S. citizen, child, adult, it doesn't matter, they will not be affected by this new rule. That includes lawful permanent residents. Because they have already been admitted to the United States, they have permanent residency status, they will not be affected. That includes lawful permanent residents that are interested in applying for U.S. citizenship. I would say probably one of the most common questions that we're receiving right now are individuals who are already lawful permanent residents and want to apply for U.S. citizenship. This is not a rule that will go into effect that will impact their eligibility for U.S. citizenship. However, That being said, it is not uncommon for a USCIS officer that is conducting an exam for naturalization or citizenship purposes to ask about the receipt of public benefits. And that's really focusing not on public charge, but on fraud. And they're really looking to determine whether someone was eligible for those benefits at the time that they received them. So the question may come up, but again, it is not relevant to the public charge rule. It has been something that predates the public charge rule and will likely continue into the future. U.S. citizen children under 21, pregnant women, we've heard many people either get off of public benefits, unenroll unnecessarily. We had a client that was a single mother and was receiving food stamps for her children, and immediately when she heard this rule announced, unenrolled her children for those benefits, despite the fact that they had a tremendous need for those benefits. So you do not need to be concerned about individuals who are receiving benefits for their U.S. citizen children. Another important category of people to understand who will not be affected by this rule are individuals who have been granted asylum. They have refugee status, people who have obtained U visa status because they were a victim of a violent crime, T visas, which are for victims of human trafficking, individuals that have a pending petition under the Violence Against Women's Act, or individuals that are in special immigrant juvenile status. I realize that there's a typo on this slide. It should be SIJS status. Also, individuals renewing TPS or DACA, temporary protected status, and the deferred action for recent childhood arrivals, those are not applications that are based on admission. They're not permanent residency status, so they will not be affected by this rule. And I also want to make clear, because I think there's a big misunderstanding, that individuals who are permanent residents or U.S. citizens that are petitioning for their family members, it is not a problem if they are receiving public benefits. The government is really only looking at the family member that is being petitioned, so the beneficiary of an application, as to whether or not the use of benefits can be counted against them. So it doesn't apply to the petitioner, it strictly applies to the beneficiary or the applicant. So I also want to just mention that if any of you have questions during this webinar, you do have the ability to ask those questions, and I would encourage you to do so. So I know that all the attendees are muted, so we can't hear you, but you can certainly ask a question, and I will do my best to answer those questions for you. Okay, so what government programs are still safe to use? Again, I think this new rule has created a tremendous amount of fear in the community, where people are enrolling in programs that are completely permissible and will not impact their eligibility. So any sort of school-based services or benefits that includes the free and reduced lunch, Head Start programs, etc. Emergency Medicaid, and Medicaid is obviously the federal government terminology for what we in California refer to as Medi-Cal. Also state-funded Medi-Cal. Now, this is a little tricky because it's very difficult, especially for the applicant or the immigrant, the beneficiary, to understand the funding source for whatever benefit that they are receiving. But it is an important point to clarify. If someone is receiving a benefit and it's strictly utilizing state-funded Medi-Cal or those funds, that is permissible. They cannot utilize any Medi-Cal benefit that is funded by the federal government. So it's very difficult to to know because it's an internal code that's used, but those of you that are tasked with signing people up for benefits, it's important that you understand that difference. The CHIP program, the Children's Health Insurance Program, is permissible. The AIDS Drug Assistance Program is permissible. Services provided under Individual Disabilities Education Act, benefits for women during pregnancy, programs such as WIC is permissible, and disaster relief. As a part of this webinar, we do have a series of handouts that we've made available to all of the attendees. The handouts include our public charge rule that we have handed out to the community, both in English and Spanish. But there's also a handout from the National Immigration Legal Center that I think is really valuable. It provides an overview of federal public benefit programs, and it kind of outlines who is eligible to utilize those programs and who is not. So if you want kind of a quick cheat sheet, if you will, or a resource to refer to, I highly recommend that you access that handout that we've made available. Okay. So talking specifically about health and health insurance. So this is the exact language that USCIS, which is under the Department of Homeland Security, U.S. Citizenship and Immigration Services, will be looking at. It states medical condition that is likely to require extensive medical treatment or institutionalization, or that will interfere with the alien's ability to provide and care for him or herself, to attend school, or to work. It's a pretty broad generalization. So we have individuals, for example, that may have cancer, and they may be utilizing non-state funded Medi-Cal to be able to undergo treatment. Some of them may be the emergency Medicaid or the emergency Medi-Cal, like which I mentioned, is completely permissible. But any treatment that is being received for any type of extensive medical condition is going to be a negative factor. So we've had conversations with potential clients having to evaluate in terms of if they are utilizing any sort of public program that would deem them a public charge, that they have to basically make a decision as to whether to pursue their lawful permanent residency or to undergo treatment. And that is a kind of case-by-case personal decision that needs to be evaluated by the individual. Our job as lawyers is simply to explain to them the pros and cons or the consequences should they decide to continue utilizing those benefits. And the individual must have or likely to have private health insurance or the financial resources to pay for health insurance in the foreseeable future, or to be able to cover those costs for their medical treatment. Private health insurance would not include state-funded coverage, and although the coverage offered under the Affordable Care Act would be permissible, it is not considered permissible for purposes of a finding of a positive factor finding for public charge purposes. So if they have, Affordable Care Act coverage, it's better than having no coverage at all, but it still will not be considered a positive factor for them. So to the extent possible that an individual can pay for and qualify for private health insurance, the better. If they have it through an employer, that is perfectly permissible. Okay, in terms of the public benefits, so an applicant who has received any of these public benefits for more than 12 months in the aggregate, so it doesn't need to be a consecutive 12 months, they're going to be looking at a 36-month period. They will be found inadmissible on public charge grounds. And I wanted you to kind of be able to see a difference. Previously, those of us in the immigration area were well aware of the impact of SSI, TANF, kind of general leave, things like welfare, financial assistance, institutionalization for long-term care. Now, one of the things that the public charge rule did was that it added essentially a second group of 5 programs that did not previously exist. So you see there on the slide the 5 additional programs that are now taken into consideration. And like I said, if an individual has utilized these programs for a 12-month period within a 36-month period, and that is in the aggregate, they would be deemed a public charge. Now, if they've received these programs for some period less than 12 months within a 36-month period prior to submitting their application, it will still be considered a negative factor, but it won't deem them automatically inadmissible on public charge grounds. Okay, so why is it important for individuals to be educated and to be informed about the public charge rule? If an individual is denied, meaning their application to apply for permanent residency is denied on the basis of public charge, U.S. Citizenship and Immigration Services has discretion to permit them to post a bond. We don't know at this point in time if there is a maximum to the bond or exactly the calculation that's going to be made to ascertain what that amount will be for any one applicant, but it will be no less than $8,100. So that applicant would need to be able to essentially pay a bond to the government of at least $8,100 in order to overcome that public charge ground of inadmissibility. If USCIS does not allow the individual to post a bond, or perhaps the individual does not have the financial capacity to pay that bond, that application will still be denied, and they may be referred to the immigration court for removal or deportation proceedings to be initiated so that they would be removed from the United States. So as you can imagine, the risks are extremely high. I think it's very important that every individual can understand what the risks are because it's not simply a matter of their application is denied, they lose the application fees, and they're basically back in the position they were prior to applying, or if they had not applied at all. Really, their situation could be far worse and they can be removed from the United States. So that assessment and that evaluation on the basis of public charge is imperative. Here at our office, we have an entire supplemental public charge questionnaire that is almost as lengthy as our regular intake form that we go through the very specific factors that are going to be taken into consideration and evaluated. It's also important to know that unlike other grounds of inadmissibility, there is no waiver. So there's no hardship waiver. There's nothing that can be filed once a public charge ground has been established by the government. So either they pay the bond or they try to defend themselves in immigration court. So here's the important part, and I think the real important aspect for those of you that work for healthcare groups, agencies, clinics, community-based organizations in terms of what you can do. So first and foremost, I think it's important that we are educating our clients, our patients, constituents, and our communities about this new rule, even if it is not in effect as of now. We do anticipate the biggest issue with regards to these federal injunctions had more to do with the lack of notice from the time that the forms were changed. Notice was given for individuals to have to utilize the new application forms that really go into these public charge factors rather than the rule being kind of completely deemed unconstitutional or unlawful. So we'll have to wait still to find out where things land. There's now, I believe, 5 federal courts as of yesterday that have issued either local or nationwide injunctions on this rule. So we'll have to wait and see. But I think nonetheless, our clients and our patients need to be aware of the implications and ramifications should they utilize public benefits. So again, you want to also be clear that you're not just educating the immigrant individuals or people who, I should say, are without legal status or perhaps some other type of temporary legal status, but also to please assure your U.S. citizen and lawful permanent resident clients, as well as those that are asylees, refugees, U visa, T visa, VAWA, CIGIS applicants, they don't need to be concerned. Please, please, please just assure them that they can continue to use those benefits without any implications or ramifications to their status. I think that's really important. So many people are, like I said earlier, unenrolling for these benefits because they're afraid, and it just kind of the fear is prevalent, and it's unnecessary for those individuals that I just mentioned to have to either not apply for benefits or to unenroll. I also think it's really important that your agency or your organization or your clinic that you establish kind of organization-wide screening and referral protocol. What we've been seeing and hearing from different organizations is because there's been no established protocol, it depends on the knowledge or information that frontline staff person has as to how they will treat or direct or assist any potential client, patient, or individual. So I think at the very least, I think it's important for some sort of, whether it's a sign or a handout that's provided to individuals prior to enrolling or unenrolling, that simply states that if you are not a U.S. citizen, lawful permanent resident, or have any of the following statuses, and I laid them out there, please seek legal advice from an attorney. Applying for public benefits may impact your ability for a future immigration benefit. I know for a lot of staff, we've been asked for kind of training and clarification that they want to be able to help the client, ascertain the impact, or they want to be able to clarify or advise them as to whether or not applying for this benefit will have an impact or will affect their immigration status. And I think, unfortunately, I am not a public benefits expert. I have been practicing in immigration law for almost 20 years. I'm an expert in terms of the immigration consequences of the public benefit programs. But again, I feel, personally even stretched to really understand public benefits even better so that I can advise our clients better. But for a line staff person that doesn't have legal education, that doesn't have an understanding of immigration law, it is simply not possible for them to be able to advise or give concrete direction or consultation for those patients. I think the best thing that any frontline staff person can do is strictly give them the information that they should seek advice from an attorney, but not to try to give them that advice at the clinic or at the community-based organization. It's also super helpful if the individual can be given information or the application about the benefit that they're seeking to enroll in, because that way when they take it to the attorney or the legal service provider, they can be clear on exactly what the benefit is that they're seeking, because that's not always clear to the individual, and that way we can evaluate in terms of what the immigration consequences might be. I think it's really, I should mention one other question that we do get from time to time is that, the same thing goes for doctors or for nurses or PAs who are having the direct contact with the patient. They want to be helpful and they want to be able to educate and inform the patient of potential consequences. And my general position is that really shouldn't be the role of that medical provider or the doctor or that nurse. It really should be that intake person, the front desk person, the organization, the clinic staff that is providing these types of advisors to the applicant or to the individual. I also highly encourage that you identify the Department of Justice accredited organizations and legal nonprofit and loyal referral sources in your area. At the bottom of this slide, we've included a link that you can go to that basically gives an exhaustive list. I think there's just under 1,000, maybe about 860, 870 Department of Justice accredited organizations. And these are organizations that have the basic education, skills, and training to be able to handle with some level of competency immigration cases. So they're not licensed attorneys, but they're certainly competent and capable of providing legal advice. And if there's any case or matter that is outside of the scope of their expertise, then they certainly know to discontinue their assistance, and they typically will refer them to another source that may be able to assist that individual sooner. So in Orange County, we have a number of DOJ accredited organizations you could look up on that list. We also, I believe, we attached the handout for that complete exhausted list. If you go to the handout section as well, I believe the entire list should be there. But also reach out to the legal nonprofit organizations in your community. Develop a relationship with them. Find out if they can assist individuals with providing legal advice as it pertains to public charge and to this new rule. So to the extent that you can do that in advance, I think the better your organization or your clinic or your agency will be to best assist and direct individuals to those resources. And then lastly, I would just say, discourage clients from discontinuing benefits or applying for benefits without seeking legal consultation. It goes both ways. They shouldn't discontinue them, obviously, if they no longer have a need for them. But I think what we're hearing and what we're seeing is a lot of people just simply out of fear wanting to discontinue the benefits. And are doing so without really understanding that it's not necessary or the public rule charge does not apply to them. So please, please, please encourage them to seek legal advice before they make a decision either way. So another, I think, a couple of important points that I want to mention is I think it is important to know that if an individual is not eligible to apply for permanent residency or a green card now or at any time in the near future, there may be no reason or benefit for them to give up their public benefits right now. So there are some individuals that may never be eligible to apply for a green card. They've triggered what we call a permanent bar. They have other immigration violations. They've been previously ordered, removed from the United States. So if this rule is only relevant to individuals who want to apply to permanent residency, I can't kind of reiterate that enough. So citizenship, it doesn't apply to. If they're trying to seek a visa outside, then yes, this is something that would be relevant or important for them to know, especially if it's an immigrant visa. But again, if individuals don't have the opportunity in the near future, we do have some clients that, their priority date is still 10, 15 years away, and they're concerned about the public benefits now. And I generally tell those individuals that, if they have a need for that benefit, we can revisit the conversation in 10 and 15 years, because who knows what the law will be at that point in time, and it's not something that is going to impact them right now in terms of deeming them ineligible for a benefit because they're not eligible for one to begin with. And then please, 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 as helpful as you may wish to be for the safety and security of the individual, please don't refer them or send them to the U.S. Citizenship and Immigration Services, U.S. Immigration Customs Enforcement, or the Department of Homeland Security Office, or any law enforcement agency tasked with enforcing our immigration laws for evaluation or advice. First of all, those individuals that manage those offices, for the most part, most of the offices are closed to the public right now. But even if they are successful in speaking to an officer. Those officers are not lawyers. They are not experts in evaluating cases for public charge ground. The only way you can really get the government's opinion on a public charge case is by filing an application. And even then, it's really hit or miss in terms of the adjudicator that you get and how strictly they are going to apply or enforce the new public charge rule or not. So, but by sending them to U.S. Citizenship and Immigration Services, those offices are often in the same building as Immigration Customs Enforcement. And for some of these applicants, it may be like sending them into the lion's den. By turning themselves into ICE, they could be apprehended, detained, and eventually deported just because someone misadvised them and instructed them to go and inquire with the government. The government will not be able to provide any type of position or advice, like I said, only if the individual actually applies for benefits. So in addition to what steps the clinics, the CBOs, the organizations can do, here are some real practical steps that we try to educate people about that we think is really important, that what they can be doing now to avoid being deemed a public charge in the future. So because we know that, financial status is a factor to be taken into consideration to the extent that they can place assets in their name if they have assets. We understand and are aware that many people could own property. It may be in a child's name or a brother's name because they're U.S. citizens or lawful permanent residents. But to the extent they're able to place those names, either those properties in their name, either jointly or on their own, the better. Because then they'll have, documentation to establish that they have assets and resources available. They should also minimize accumulation of debt, and that includes credit cards and loans. Again, it's a factor that's going to be evaluated, and so that they can demonstrate their ability to be financially independent and self-sufficient. We also highly encourage individuals to register for ESL courses at a local community college or community center so that they can learn to read and write. I often share the story that it's never too late. My grandmother was 84 when she applied for U.S. citizenship, and she did not speak English. And even at the age of 84, was taking courses at her senior center locally. So I always tell people it's never too late. They really need to begin taking English language courses if they are not fluent in the English language. Individuals should also either obtain, or if they already have them, keep licenses or certifications that demonstrate English proficiency if they've, reached a certain level, or any professional skill or license that they may have. And that includes licenses that they may have abroad or ones that they've obtained here in the United States. Anything that's going to help convince the government that they are marketable, that they are employable, that they will be able to be employed here in the United States. We also want individuals to keep records of employment and income of their income, of their employment and their income. So that includes things like their paycheck stubs, their federal tax returns, bank statements, documents related to credit history or their credit score, anything that's going to show some sort of history or longevity in terms of having, this amount of financial resources or income, et cetera, so that the government will be able to say over a period of time that you've been able to maintain this certain income level or this certain, asset level sufficiently. It's going to all depend on documentation. They will not take one's word for it. And then if possible, it would be important for them to consider purchasing private health insurance to avoid, again, any presumption that they're going to be a public charge. Here on this slide is the website to USCIS, U.S. Citizenship and Immigration Services. They do have a lot of great information, and if you even search public charge within that website, you will find the latest information. I believe there's a notice up there right now regarding the injunctions. So you can find kind of the latest information about the public charge rule, when it will go into effect, if it will go into effect, etc. The new applications, which have changed drastically, although they were posted, I believe, like 48 hours before the rule was to go into effect, they've all been taken down from the website, so you can't access those new forms right now, and nor should they be used by anyone until further notice. The rule has been made final, or the government has permission to utilize those new forms. On the screen, you also have our contact information. Please consider us a resource of any kind. Like I said, we've got handouts and materials that our office produces. You're welcome to sign up for our e-newsletter. We don't bombard people with information, but if there's any major change with regards to public charge or DREAM Act or DACA, anything significant that would impact immigrants in our communities, then we will send out that information. So you're welcome to sign up for our e-newsletter. And again, any questions or issues, problems, comments, cases that you need assistance with, feel free to give us a call or shoot us an email. You have our social media handles on on this last slide as well. So I wanted to make sure that we had at least 15 minutes. I know that there's a lot of questions for individuals that are practicing in various areas to ask. If anyone has a question, I would encourage you to go ahead and post that now, and I will do my best to get through all of the questions and answer them. So the question that I see here posted, it says coverage elsewhere. And I'm not exactly sure what that means, if there's coverage elsewhere. If you ask that question and don't mind responding or clarifying, then I can answer that better. Okay, so someone wants to know in terms of what materials that they should make available to their clients and patients. Like I said, we have handouts that our office created. They are available on this webinar. You're welcome to download them and distribute those handouts. We are not proprietary about the content. We do put a lot of time and energy to try to make it as user-friendly and easy to read as possible. But you're welcome to distribute those materials to anyone you think would benefit from them. But I think it's also really important that each organization not only conducts a training for their staff, especially their frontline staff, but that they also have their own handout in the sense of that advisory, right? To encourage and to assure those people that are U.S. citizens and lawful permanent residents or asylees, refugees, VAWA, T visa, U visa, for them not to be concerned to utilize those benefits, but for those who are not, do not fall into that category, that you are encouraging them to seek legal advice before they enroll in benefits. Implemented eventually. Implemented event. So maybe the question is this rule going to be implemented eventually? So one of the things, and again, on the handout that we have for the public, so this rule is not being implemented in the United States. So for domestic applications for lawful permanent residency, USCIS is not implementing this rule. It has not yet gone into effect. However, the State Department, which oversees all of the embassies and consulates around the world, has adopted this rule, and it has been implemented, and it is in effect. So it's really important, like I said, it's not just thinking about people that are applying for permanent residency domestically, but it's people who are applying not just for immigrant visas or like their permanent residency abroad, but also any other type of visa, work-related visa, student visa, visitor's visa, investor's visa, anything. Now, obviously, the higher the skill of the individual, the more financially established, this rule isn't going to really impact them on a practical level. If they have a health condition, they may, if they do not have private health insurance. But for the most part, it's not going to impact those individuals. It's going to be, like I said, the low income, elderly individuals that are going to be most impacted. So the State Department has already and will continue to implement this rule and those factors. We've already seen it come into play for some of our clients here at our office, and so we need to be very careful. Like I said before, when someone was going through the consular process, the affidavit of support, the petitioner or sponsor's income was sufficient to avoid this finding of public charge. That's no longer the case. We have individuals that have well-established jobs abroad, but they're not fluent in English. They don't have a job offer here in the U.S. because they haven't officially immigrated, that the consular officers are already asking and basically intending to deny their visa. We even actually had one person's visa get denied because they failed to establish that they were of working age, had financial means, had a job offer, and did not speak English fluently to avoid a public charge finding. So as much as things have been halted here in the U.S., they are certainly moving forward abroad. I do anticipate that some version of this rule will become final. Those forms will be released, and immigrants will be subject to this new rule. So it's important that we're mindful of it, that people are being aware of the consequences, and we're doing everything we possibly can to educate our constituents. All right. Are there any other questions that folks have? Okay, I think I may have gotten off easy. Following this webinar, the webinar has been recorded. If you find it will be beneficial, we'll go ahead and send that out. And you're welcome to share the link to the webinar to your colleagues, to your staff, to anyone else that you think would benefit from this information. So I will stick around. If you do have any other follow-up questions, like I said, feel free to email me. You can feel free to give us a call. Feel free to ask the question. But I think this will conclude our webinar for the time being. I want to thank you again for joining us and for your care and concern for the communities that you serve. And I hope that all of you found this information useful and beneficial, and will share it with your constituents. So thank you again for joining us.